This is Christopher Smith with a Liberty Minute.
Hello, America. Today, we interrupt our three-part series on conservative solutions for immigration reform to address what Californians are feeling right now as a supreme slap in the face by a rather malicious ruling that came down from Judge Vaughn Walker on Proposition 8 yesterday. In what will certainly be viewed as a landmark miscarriage of constitutional justice by an openly gay lower court judge, overruled the sovereign authority and will of the voters with the Proposition 8 initiative through pure partisan politicking from the bench. First off, let's set some groundwork on this topic. No matter where you come down on this issue, being objective first and secondly, intellectually honest, you'd be hard-pressed to say that constitutional justice was actually advanced yesterday. You'd also be equally hard-pressed to not get a message that was very clearly sent in the most licentious manner possible that our electorate is irrelevant and we will do precisely what we want. This judge did three things that were very disturbing and need to be addressed straight away. One, mainly, he should have recused himself from the court choice. Heck, we might as well let all the foxes tell us how many hens are in a coop if we're going to buy his I can be objective argument. And clearly, he was not. Two, it was very distressing how he divided the 14th Amendment. On one hand, the valid position granted through due process the people took to address the only constitutional means our framers gave us to deal with so-called social issues through referendum, he completely invalidated. On the other hand, he falsely advanced the equivocation of a behavior or vice, well, I guess it depends on how you look at it, with one's inalienable rights as a citizen. The Constitution is very clear on this and has no room for personal interpretation. It protects what you are, not who you become. Lastly, he based his opinion on a moot straw man. To somehow suggest that Proposition 8 was discriminatory is, in fact, the straw man. Law by its very nature is discriminatory. There's no big gotcha moment here, it's just what it is. Law openly draws distinctions based upon standards set by people who shape the legal standards observed by the status quo in a given culture. What Judge Walker advanced was nothing short of a technocratic coup. He blatantly ignored the will of the people and cobbled together some loose-leaf binder/crib note excuse rather than a viable, objective, lawful opinion. There are no equivocation arguments that will ever make the U.S. Constitution protect behavior, period. The sum of his myopic disposition was to falsely assert that Equal Protection Clause somehow protects the subjective value of their behavior over the objective value of their citizenship. He's dead wrong on that. However, don't take my word for it. The opinions posted and can be read on my Facebook page. Just look up facebook.com/SmithWin2010 or type in Christopher Smith, and you can read it there. On its face, Judge Walker's decision was patently unconstitutional because it makes a mockery out of the 14th Amendment. The states have the right to regulate marriage through the authority of the 10th Amendment. Unless the federal government perceives a threat to the posterity of the Union, then Congress is charged by the enumerated powers in Article 1 to address the issue to create a standard for the states to apply unilaterally. Thomas Jefferson saw how to deal with the problem of what he called a black-robed oligarchy with respect to perceived judicial tyranny. If the only way the gay lobby can advance their so-called rights is through obstruction, obfuscation, baseless equivocation, lying, judicial fiat, and other technocratic malaise, well, I'd say maybe what you're about isn't worth table salt. But since the goal of progressives today is to make Congress irrelevant and to supplant it with bureaucrats in D.C. who want nothing short of nanny-state strong-arm equivocation, we need to rid ourselves of judges with agendas and worldviews not consistent with the Constitution. This is precisely why Jefferson enacted the Judicial Act of 1802. This was simple. Judges have a job description, like we all do. If you cannot act to defend the Constitution and preserve the Union, basically perform your job duties within the limits of the oath you freely agreed to take, then the people want their bench back. No static, no Article 3 sessions, no need to prove treason because no treason was alleged. Just recall the judge. If you can't follow instructions, then you don't need to handle the job the people gave you. Plain and simple. Folks, restoring America is a lot less complicated than it's been projected. We can set America back on a productive path, but it starts with sending people to Washington you can trust instead of people parties can trust. And when we do that, we will restore America. What do you think? I'm Christopher Smith.